agents, and welcome to another Deal Doctor live stream. I apologize for a delay. Apparently, I didn't have admin rights for a moment. All right, welcome, five-star real estate agents, and welcome to Deal Doctor live stream. We're going to be talking about seller's disclosures and when a seller disclosure is needed and when a seller disclosure is exempt. Now, what is a seller's disclosure, or what are my disclosure obligations for a client would be a question that we'd start with. And one is, when a seller is putting a house on the market in Michigan, it involves providing specific written information to buyers about the house's physical condition. Now, there are times where we will look at the seller disclosure, and maybe it's confusing, but we want to try to work through what the seller disclosure is, what its purpose is, and then also with the seller disclosure, when is it not required or exempt. Now, before selling a residential property in Michigan, a seller is required by law to tell the prospective buyer certain things about the property's physical condition. Now, this comes from the Michigan Seller's Disclosure Act, this requirement. And as a seller, you must disclose certain information by completing a written disclosure statement and giving it to the buyer. Now, when it comes to seller's disclosure, again, the resident is required to fill out a document to ensure that we provide certain information about the condition of a home. And one of the questions comes up is who is required to fill out a seller's disclosure? And in Michigan, all individuals who are selling a 1 to 4 unit property will need to fill out a seller's disclosure form. And for starters, you want to make sure that it is consisting between a 1 to a 4 unit. And this would be an example of a single family home, or a larger building that contains up to 4 apartments would require that documentation. Now, the disclosure requirements go beyond standard sales, however. You must comply with disclosure requirements even if you are selling a property by a property exchange. Maybe a land contract, you're still going to need a seller's disclosure, or an option to purchase agreement. You could have even including a lease with option to purchase, or a ground lease, or a transfer of stock or interest in a residential cooperative. So with all of those, we will need a seller's disclosure if it's 1 to 4 units. Now, exceptions to the Michigan disclosure requirement is that in some limited circumstances, sellers are not required to comply with the seller's disclosure law. Now, some documents, when you download the seller's disclosure, there is a one-pager in the front of that will actually explain all of the times that a seller's disclosure is exempt. Or if you look up Michigan occupational codes in real estate, you can also look up seller's disclosure and exempt. And there is a listing there in the occupational code of those items or times that a seller will not need to fill out a seller's disclosure. Now, some of the ones that we are more familiar with is typically, you'll see this during transfers pursuant to a court order, including maybe a probate or a writ of execution. A foreclosure sale would be another option. Maybe those made by a trustee in bankruptcy. Transfers by eminent domain. See transfers resulting from maybe a decree for specific performance. You might see. We normally see exemptions, meaning we don't need the seller's disclosure when we transfer between a sale under a power of sale or a decree of foreclosure. We will not need a seller's disclosure where the bank has it now, and it's now a real estate owned property. We're not going to see a seller's disclosure. You're not going to see a seller's disclosure during the course of administration of a decedent's estate, or a guardianship, or conservatorship, or a trust. You're not going to see a Michigan seller's disclosure. Even transfers between co-tenants, transfers between a husband and spouse, maybe during a divorce, you're not going to see a seller's disclosure. Transfers from any governmental entity, you're not going to see. Are certain transfers of newly constructed residential property that has not been inhabited. So again, new construction that hasn't been inhabited yet, you're not going to see that seller's disclosure. Now, filling out the Michigan disclosure statement. Now, Michigan requires sellers to use a standardized form for property disclosures called the seller disclosure statement and sets forth the language for it within the actual law. Now, this form is essentially a checklist asking you to indicate the condition of various features of the property, such as appliances, roof, basement, your HVAC systems, furnace, AC, and any known problems affecting it, such as maybe encroachment issues, could be environmental issues, or pending legal issues. Now, while some states have specifically addressed whether or not sellers must disclose whether a property is stigmatized, let's say by poltergeists, death, murder, infectious disease, and so forth, Michigan has not been a state that's been required. It came across one time where a person coming from New Jersey wanted to know if a home had any poltergeist activity. So no, we don't have to disclose that. Now, there are some laws that came out a few years ago where someone did end up getting in trouble because they didn't disclose a certain fact when they were asked. So as an agent, if you know something and you are asked by the public, you are required to tell the truth. And if you don't, you could be in violation of the Code of Ethics, not acting honestly with the public. So we just need to be mindful that when you are asked a certain question, to be truthful. But the seller's disclosure does not require certain issues or stigmatized property to be disclosed. Now, we always continue to tell agents that when in doubt about whether to disclose a particular issue, it's usually best to do so. Disclose is key to everything to prevent a lawsuit, not only for your seller, but also for the agent, because if the agent also goes along with this and knows that there is something wrong, let's say there's a water leak in the roof, they've seen it, they know it's there, and then the seller goes back and just slaps some white paint on it, that agent is still required to let buyers know that before an offer is presented. You can't hide material defects. Now, that's different than a latent defect, which is something that we don't know. Maybe there's a leak that happened behind the wall, maybe some plumbing, there's been water, and there's no way for anyone to know unless you were to pull away the wall. That's considered a latent defect, where no one would know unless you did some exploratory to determine what the cause of that issue or where it's coming from. Now, sellers are required to present a disclosure statement. I should say agents are required to present a disclosure statement to that seller and tell them that, hey, we need to have this filled out. Once that's filled out, we are then required to provide that seller's disclosure to any prospective buyer or buyer's agent prior to signing the purchase agreement or sales contract. Now, complying with this timing requirement is crucial because the buyer may terminate the purchase agreement if you deliver this disclosure late or after the signing of the purchase agreement. They have like 72 hours. And let's say you sign a purchase agreement, but then you give them the lead-based paint or seller's disclosure after the fact. Well, they now have time to review that and terminate within so many days. So it's always important to ensure that those are filled out and provided on the MLS, or copies are there at the open house as well as people come through. Now, limits on information Michigan home sellers must disclose. Now, the Michigan disclosure statement requires that you disclose only information about the property that you actually and personally know. Now, this has always been a concern. People say, well, I just received this home inspection from someone. Do I now need to disclose it? And the current laws are simply this. Sellers must disclose only information about the property that they actually and personally know. If they get secondhand information from an inspector, that's not information that they personally know or that they are aware of. Now, we would encourage that they disclose that information, but they are not liable for that information that came from that inspector or a third party. So Michigan law is very clear on this, that if we get information from a third party, the seller is not responsible for the liability of that third party information. Again, the seller disclosure has only been set up for the seller who personally knows about the property to provide what's called best information available. That's the legal term, right? Best information available that they have personally about the property. And that's why we have a seller's disclosure, for them to disclose everything that they know to the best available information that they have, not a third party. Now, in other words, you need not perform any investigation of a property before completing the form, though if you've done so, you must reveal the results. So those individuals who like to do pre-inspections, once you know the results, you're going to need to disclose that information. But again, if you have a copy of that inspection, you may not be liable for that, but you should still disclose it and have a copy for someone to look at. If a seller doesn't know certain information requested on the form, they can satisfy the disclosure requirement by checking the unknown box. You'll see that in the seller's disclosure, you have a bunch of check boxes there. And that's talking about specifically information about, let's say, your stove or refrigerator, whether they're in working order. That whole box and all that language there doesn't mean that those information or those items are staying with the house. There's a confusion there that people say, well, yep, there's a stove here, there's a furnace, hot water heater, humidifier, unknown or not available. Those check boxes are only there to ensure that the items that are in the home are in working order. And if you read the fine print above that, that's what it states, working order. And the information that you enter on the form, just again, you can't help fill them out. You need to make sure that you say, seller, here's the seller's disclosure. I'm not allowed to help you fill this out, but this is the information that you do need to fill out. But I always try to help them understand that, hey, in this section where it talks about the furnace and whatnot, please read this fine print above here, because this is basically asking if these items are in working order. And then your options are yes, no, not applicable, or unknown. Now, what happens to sellers who violate Michigan disclosure requirements? Now, if you violate Michigan's disclosure law, for example, by failing to provide a complete written disclosure, or you intentionally misrepresent information, the buyer may cancel the purchase agreement prior to closing. We're seeing more and more of this where someone finds out information just a week before close that wasn't disclosed. And then we have to get attorneys involved, and they end up terminating the purchase agreement because something wasn't disclosed properly on that seller's disclosure format. And it turns into an ugly mess. So again, when you're talking with your client, ensure that they disclose everything that they can. I think so many times sellers are afraid to disclose maybe some water that came into the basement for fear that it might stigmatize their property. But people understand with the weather, the changes, a simple clogged gutter, there might have gotten water in the basement. We corrected it and we cured it, and there are no other issues. They need to be honest and truthful as best they can. When they don't, or when they try to do white lies, then it comes back to bite them. So just let them be aware that they want to be as truthful as possible when it comes to disclosing. Another issue that we see, what happens if we violate Michigan disclosure law, is that if the closing has already occurred, the buyer may pursue legal action against the seller for fraud. So if the seller puts something in there or doesn't put anything in there, like a roof never leaked, but then we go up in there and there was a huge area that was replaced, and now we're having ongoing issues and problems with that area that we weren't told about, that could be potentially fraud. So a buyer may pursue legal action against the seller for fraud on the basis of misrepresentation, or what's more importantly, omission. Now, the buyer may also separately sue the seller for fraud or misrepresentation. So there's two different things here. You can be sued for misrepresentation or omission of something. You could also be sued separately for fraud or misrepresentation. So it can get real ugly in the courts for people. So just be mindful that when it comes to disclosure laws, continue to encourage your seller to make sure they disclose. And the other concern is that if you, as a listing agent helping your client, if you also willingly know of issues and you don't disclose, you too could fall into a trap of being sued for those issues that we've just talked about with regards to misrepresentation or omission. So that's all I have on the seller's disclosure. I just want to remind you that there is a lot of times where that seller's disclosure is exempt. We can find that, you can just Google it, even occupational code, Michigan occupational code, real estate seller's disclosure, and you'll see a section, I forget the number, but A through J or A through I, there's about 7 or 8 different items there that can explain that the seller's disclosure and certain times that they're exempt. But if you still have questions and you need additional help, you can always reach out to the Deal Doctors. That number is 616-490-0902. Speak with Don or myself or any of your broker's reports staff. We're here to help you get through and answer any questions that you have. So I hope you enjoy the rest of your week and have a great day. Take care.